I'm Bill Roller, president of the Berkeley Group Education Foundation and partner in the creation of today's program. I want to thank the Miller Institute for Global Challenges in the Law, Berkeley's Law's Human Rights Center, and the Henderson Center for Social Justice for their essential roles in making this symposium possible. Special thanks must also go to Kate Jastrom, faculty director of the Miller Global Institute, for her support and all that she's done. And thanks also goes to Karen Chin, administrator of the Miller Institute, for her help as well. The brochure indicates that our program will end at 5:30, but our panel will be taking questions from the audience until 6:15. So don't run away. We'll have lots of things to do, and you want to take part in our discussion. Today's proceedings will be videotaped and placed on YouTube for dissemination to the general public. After making a few remarks, I shall introduce the members of our panel in the order presented in our brochure. Each panelist will have 10 minutes to make an opening statement. Our panel will then devote 15 minutes to respond to each member's comments along the lines of a particular theme. At that time, I'll ask an opening question of each panelist to get us started. We shall close the day with a 45-minute question and answer session with our audience. Our symposium on torture met initially at Berkeley Law in November of 2010. Since then, no lawyers have been held accountable for sanctioning torture, no psychologists have been held accountable for their role in torture, and the only Pentagon or CIA operative prosecuted to date is John Kiriakou, who blew the whistle on the CIA torture program. What is sobering to me is that we could meet again in 4.5 years and nothing will have changed. Juan Mendez, the special rapporteur on torture for the United Nations, told a gathering at Berkeley Law this past week that he deplored President Obama's decision not to investigate, prosecute, and punish those responsible for the inception and perpetuation of the U.S. torture program since 2001. I hope that what we say here today will make a case for our government to do so. I am the only mental health professional on this symposium, so I want to speak briefly about the involvement of U.S. psychologists in the planning and execution of torture. In 2005, the American Psychological Association participated in a task force on psychological ethics and national security, or PENS for short. Psychologist Jean Maria Arrigo, a member of our symposium in 2010, was appointed to the task force. Arrigo now believes she was placed on the task force to give the CIA and Pentagon back to psychologists the cover they needed to make it appear legitimate. In fact, the task force was rigged by CIA and the Pentagon. Most of the 10 members had close connections with the defense or intelligence community. Arrigo's voice of protest was effectively silenced. The task force endorsed the involvement of psychologists in CIA interrogation programs. As James Risen puts it in his book, Pay Any Price, quote, "The involvement of psychologists in the interrogations helped the lawyers in the Justice Department to argue that the enhanced interrogation program was legal because health professionals were monitoring the interrogations. The APA and the psychological establishment did not challenge the conclusions of the task force and effectively turned a blind eye to the torture they sanctioned. They became a psychological fig leaf to cover not only the Office of Legal Counsel's memoranda of August 1st, 2002, authored by John Yoo and others, but also the September 17th, 2001 Memorandum of Notification, signed by George W. Bush. The Senate Intelligence Committee report indicates that both these documents were drafted by the CIA. I trust our panel member, Mark Danner, will give us more details concerning this revelation. The Senate Intelligence Report also reveals that the CIA paid 2 psychologists who had no interrogation experience $81 million for an interrogation program that had no scientific or empirical basis. Furthermore, the claims that the program produced evidence that saved lives were patently false. Torturing is scapegoating in the extreme and is rationalized in the belief that it somehow advances the cause of national security. Following that belief and their own anxiety, officials would rather torture than be blamed for a disastrous attack. And yet, the fact of torture itself undermines national security by providing cause for blowback, retaliation by groups who identify with the victims of torture. One of the most enduring forms of scapegoating is the practice of torture. It is often referred to as an inescapable and immutable part of human nature. However, the social psychology experiment that Philip Zimbardo and I completed in 2014, which we call the Berkeley Civic Courage and Heroism Experiment, demonstrates that scapegoating is neither necessary nor inevitable in group formation and behavior. It can be actively resisted by appropriate leadership and the establishment of norms that prohibit abuse. Mark Danner, in reviewing the recently published Guantanamo Diary, has suggested that we Americans have become the inheritors of a postmodern version of the Salem witch trials. In justifying torture, our leaders have conjured up a fantasy world born of the collective terrors of their own imaginations. We are here today to affirm that the social norms of empathy and identification with the other and the stranger must be enshrined and defended in the law. We reiterate that those who violate these norms must be held accountable. Although accountability for these violations may wait until a future time, the call for accountability must remain constant in our own time. We can do no less for those who come after us. I shall now introduce each of our panelists so they can give their opening statements. Mark Danner is Chancellor's Professor of English and Journalism at UC Berkeley, and also a Professor of Foreign Relations and Humanities at Bard College. His books include Stripping Bare the Body, Politics, Violence, and War. He is the public intellectual most responsible for keeping the subject of torture in the public eye. His topic today is Our Ignorance, Their Pain, Torture, and the Forever War. Please welcome Mark Danner.
Thank you very much, Bill. It's an honor, it's an honor to be here with this very distinguished group of people, and I want to thank Bill and Robert Cole for organizing this, and all of you for coming on a most beautiful day to discuss a most grim subject. I appreciate it. I listened to Bill's eloquent words very, very closely, and it seems to me one is tempted to say that nothing has changed in the 5 years since we gathered here, also under the auspices of Bill and Bob, to discuss these matters. But I think it's fertile also to say, well, in the absence of accountability, which is what I dare say many of us on this panel and many of us, or many of you in the audience, would be looking for, it seems fertile to ask what has changed. And it seems to me that quite a lot has changed. We are imprisoned in a world of torture, even as the torture itself was stopped, or certainly largely stopped, by President Obama as one of his first acts in office. When I say we're imprisoned in that world, I mean that the support for torture, which in 2005, in a fairly well-noticed Pew poll, was about 38%, is now 50%. 2005, the program itself was on the way to winding down. And here we are in 2014-15, and it is dramatically risen. Torture, once an anathema, has become a policy choice and a political object. When I say policy choice, I mean that were Mitt Romney elected in 2012, it seems quite possible, I don't want to say likely, but quite possible, that a Romney administration would have indeed taken up enhanced interrogation techniques once again. We had a leak from the campaign near the end of the election campaign indicating that. Torture has become a political object in that when we saw the reaction to the Senate Select Committee on Intelligence report, which was issued, a remarkable, chilling document, just the executive summary of which was issued in December, we saw an utter political division regarding the report and regarding torture itself. That is, of the two great political parties in the United States, one of them has a very clear position on torture. It is for it. This is the Republican Party. The Democratic Party is more mixed. Many oppose it. Many, many more, I would say, don't particularly like to talk about it. This is the situation we're in 5 years after our last symposium, when I think none of the statements I just made, perhaps the one about policy choice could have been made, but certainly the one about rising support for torture at that time could not have been made. So I think when we look at torture, we have to see it as a dynamic object, even though people, at least under the color of law in the hands of US officials, are no longer being waterboarded. Torture itself is still a dynamic issue that is changing and that has a dynamic political character that is carrying it in a direction that is deeply, deeply worrying. I think we can ascribe some of these consequences to the very lack of accountability that Bill so eloquently discussed. I know that part of my burden was to talk about how we got into this mess, I believe. But I think I'm going to go back and think of that as the matter for discussion and go back a second to my title, which I think was Our Ignorance, yes, Our Ignorance, Their Pain, Torture and the Forever War. There's a simple thesis behind that, which is that a lot of the reason, it seems to me, that the US government tortured, and it was various parts of the US government. It was the CIA, it was various parts of the military as well. This is a fact-rich environment, as journalists would call it. There are a million stories about how, in particular, various parts of the government tortured, what they did, what techniques they used, how they determined that it was legal, although much of the legality stems from both on the military and on the CIA side from Professor Yu here at Boalt Hall. When we look at this fact-rich environment, I'm inclined to look back and essentially say behind the decision to torture were a couple of emotional elements originally. One was panic. Richard Clark, the counterterrorism advisor in the Bush administration and several administrations before it, said rather eloquently, after 9/11 we panicked. And I think that's quite true. But I think there were other emotions. One was guilt and the surging demand that something like 9/11 never happen again, because it did happen on the Bush administration's watch. And the other, which I think is extremely important, is ignorance. Ignorance, ignorance. That is lack of knowledge about Al-Qaeda and a kind of certainty that certain prisoners who were captured, Abu Zubaydah is a significant one who was captured in March 2002, and for whom Professor Yu's memos, famous memos, were written, that these prisoners had the mother lode of information. They knew about attacks that were about to occur. And this was a fantasy. This was not true. And it was based on ignorance about who Abu Zubaydah was, first and foremost, but also on a panic need to locate the danger and destroy it. And destroying it meant showing a kind of commitment, overwhelming commitment, that it would not happen again. And I think, you know, after the Senate Select Committee on Intelligence executive summary was published, I talked to one of the writers of it, who said to me, you know, looking back on this, and this is a guy who had done nothing but sit in a small room writing several thousand pages for years about torture. He said, when I look at this, the greatest mistake was the decision not to fire George Tenet and other officials who could be deemed at least somewhat responsible for the 9/11, for letting the 9/11 attacks succeed. And I said, why? And he said, because it instilled a kind of overwhelming guilt and other black emotions at the top of the government, which eventuated in this kind of determination to do everything possible to stop a succeeding attack, stop an attack that might be coming. So you had a kind of mythology that was based on this notion that you had a few prisoners who would have the golden information, and that the only way to get the information from them, and again, we're back to ignorance, because the CIA essentially knew nothing about interrogation, as Bill mentioned, and was given the right to interrogate and detain in the September 17th, 2001 memorandum of notification that President Bush signed, a document that we still do not have, that would be very good to have. They did not know what they were doing. They hired a couple of psychologists, famously paid them to the tune of $80 million, and set off on a program that really was, and this is a strikes anyone I think who would read this report, a program of interrogation which was remarkable for its amateurishness. The report is remarkable for its brutality, for its depravity, and for the amateurishness of what goes on within it. And finally, it's remarkable also for the fact that the claim that torture was necessary to save thousands of lives, that claim pre-existed the program itself. That is, lawyers were already making that claim before the program started. And those claims have continued throughout the program's existence, and now even more vociferously and ardently in the aftermath of torture itself, and in this nether period in which torture is becoming more popular, more popularly supported, and more of a political issue that defines and divides Americans politically. And it is this conviction that torture is absolutely necessary, that we owe our lives and our safety to torture. And this conviction becomes more deeply instilled every time we have a news event like the release of the Senate Select Committee executive summary and a succeeding debate. And so far as we can tell, these convictions or these claims that torture was responsible for saving thousands or tens of thousands of lives are false. We will never have, I would dare say, an investigation as thorough as that which was made public in December. And it shows, and I've read the entire, for my sins, the entire executive summary, which I don't wish on anyone. But it is quite convincing, to a rather shocking degree, that these claims were not only false, but they were falsified with respect to administration officials as well. That is, the CIA told administration officials, including some of the program's most ardent defenders, like Vice President Dick Cheney, that tens of thousands of lives had been saved. And Vice President Cheney continues to say this, even in the wake of the report that disproves it and shows that he was made what must be called a willing dupe. Anyway, there is much more to talk about. I'm getting a time zero.
You're zeroed out.
It's a very chaste, sort of, tactful little thing.
I'm glad I'm this far away. Mine
Yes.
won't reach me.
But
Well,
there is much more to discuss. I had wanted actually to read a bit about waterboarding, and maybe we can do that in the discussion period.
I think that
Because
would be
seems to me-
appropriate,
It
yeah.
seems to me we should know a little bit about what we're talking about. But thank you for your patience. I look forward to the discussion.
Good, okay. Thank you, Mark. Our next speaker will be Jameel Jaffer. Jameel Jaffer is Deputy Director at the American Civil Liberties Union. He has litigated many cases relating to national security and human rights, including cases on surveillance, torture, rendition, and targeted killing. He co-led the litigation that resulted in the public disclosure of the Bush administration's torture memos, and most recently led the litigation that resulted in the public disclosure of the Obama administration's drone memo. He'll speak to us today about accountability for torture. Please welcome Jameel Jaffer.
So thank you for coming, and thanks very much for the invitation to speak. You know, especially, I feel like, I think we must have said this 5 years ago when we were here, that it was sort of a crucial juncture, but I feel the same way today. I'm going to make a bunch of somewhat disconnected points about accountability and torture and secrecy. And we'll just see how many of them I can get through in the time that Bill allots to me. So first, I don't know how many of you have been following and how closely you've been following the military commissions at Guantanamo. But I want to tell you about how something about something strange about the way the courtroom is set up at Guantanamo. So it looks in many respects like any courtroom you might see here in San Francisco. There is a judge who sits at the front of the room behind a bench. There is a box for a witness. There's a bigger box for the jury. There's a bar that separates the participants in the courtroom from everybody else. The prosecutors sit at one table. The defendant and the defense counsel sits at another table. The thing that distinguishes the courtroom at Guantanamo from every other courtroom you might have seen is that there's a wall that runs, a plexiglass soundproof wall that runs across the courtroom and separates the trial participants from all of the observers who come to watch the trial. And the observers include family members and NGOs and sometimes officials from other governments. And there's this soundproof wall, and there's a speaker system so that the sound is broadcast from inside the courtroom to the observers in the back. But there's a censor, there's a security official who sits next to the judge and who keeps his finger on a button. And if anybody discloses classified information or information that the government considers to be classified, the censor presses the button and the sound is cut to the observer gallery. Now that in itself, I think, is a very, to anyone to any lawyer, I think, in the United States, that's a kind of shocking thing. It's not something that you see in a courtroom. You know, our courts are designed with transparency in mind. So that in itself would be, would be surprising and disturbing. But one of the really perplexing things about it is that the whole system is designed to keep this system of secrets secret. The secrets are all relate to the treatment of prisoners in CIA custody. So these are all former CIA prisoners who were brought to Guantanamo in 2006. And in the CIA's custody, as Mark suggested, they were tortured. And now they're at Guantanamo, and this system of this sort of infrastructure of censorship is set up to prevent them from testifying publicly about their treatment in custody. And the perplexing thing is that all of that information, or virtually everything that they might say about their treatment in custody, is public already, and it's been public for a long time. Through Freedom of Information Act litigation, we've had these torture memos for many years now, since 2009. Thanks to Mark, the New York Review of Books published the Red Cross report in 2009 as well, which gives the prisoners' own accounts of their treatment in custody. We have a CIA Inspector General report that goes into the treatment of these prisoners in considerable detail. And all of that was before we had the Senate report, which gives us even more granular detail about the treatment of these prisoners. And so it's a little bit, more than a little bit, I think, odd that we have this entire system of censorship set up at Guantanamo in order to keep secret things that are already widely known. So you might ask, why have this system at all? What is it that the government wants out of this infrastructure of information control? And I think the answer doesn't lie in sort of traditional or conventional ideas about transparency and censorship and suppression. It's not about keeping facts secret. It's about accountability. It's a means of decoupling transparency from accountability. So we all know what happened now. We all have all of these facts, but the facts are not officially acknowledged. The facts aren't, by the government, considered to be true until the government itself says that they're true. And even now, after the CIA, after the Senate has released all this information, the CIA is still holding on to the argument that the executive branch hasn't acknowledged these facts, and therefore the facts shouldn't be recognized as officially true. Now, that is not about suppressing information or suppressing facts. Again, we know virtually everything there is to know now about the torture program. Maybe that's a slight exaggeration, but we certainly know a lot about the torture program. It's all about what happens with the information that we have. What can you do with that kind of information? And if it's not officially acknowledged, there's a lot you can't do with it, and I'll come back to that in just a second. The reason I bring up that infrastructure at Guantanamo, though, is that I think that there's something emblematic in this separation of, or something bigger in this idea that there are facts that we know, but that are in some sense impotent, facts that you can't do anything with. And I think that there's a sort of larger societal message in that somehow, because I feel like more generally, we've failed to reckon with the facts that we have. Our institutions have failed to reckon with the facts that we have. We have all these facts. We know what happened. But our institutions haven't operated as we would have assumed they would. There are a number of different reasons for that. And I guess I will just throw out one unoriginal thesis about it, which is that at some level, societally, we're not willing to confront the facts. We are afraid of confronting the facts. The way we normally talk about secrecy is as if the government is perpetuating an evil against the citizens, right? The government is keeping something secret from us. The government is preventing us from knowing something. And that's often obviously true. But I think there comes a point at which secrecy becomes a tool not of the government, but of the citizens themselves. Citizens use government secrecy as a means of distancing themselves from moral responsibility for the actions that the government took in their name. And I worry that that's part of what's going on with this secrecy at this point. We allow the government to pretend that these things are secret because to admit that they're not secret is to require us to do something with those facts. And I don't know, I can't make a strong case for that. It's a suspicion I have. I just think that at this point, given all the information that's out there, how do we explain the fact that our institutions haven't operated in the way that they ordinarily would be expected to? So that's to say, and I should have made this point a little more clearly, but I think that we usually think of censorship as playing a particular role. Censorship suppresses facts. And I think that in Guantanamo and more broadly with respect to torture more generally, censorship is playing at least two other roles as well. One is decoupling accountability from transparency, and the other is maybe decoupling is the right word here too, but decoupling us from moral responsibility for our actions. And I wonder whether, if we think about secrecy playing those bigger roles, we might think of secrecy as more dangerous than we have been thinking about until now. I was going to say, I was going to sort of go back to the point about secrecy and accountability and talk a little bit about why I say that we haven't had accountability, why secrecy or the failure to acknowledge facts that all of us know to be true, why that and how that has prevented us from holding officials accountable for their actions. But I think that will take me more time than I have. So I'll leave that for the discussion. I think I'll leave it at that.
Very good. Thank you, Jameel, for those incisive remarks. Our next speaker will be Rebecca Gordon. Rebecca Gordon teaches in the Philosophy Department of the University of San Francisco for the Leo T. McCarthy Center for Public Service and Common Good. She's the author of Mainstreaming Torture, Ethical Approaches in the Post-9/11 United States, recently published by Oxford University Press. A veteran of liberation movements from Central America to South Africa, she is the founder of Californians for Justice, an organization dedicated to the political enfranchisement of marginalized people. Please welcome Rebecca Gordon.
Thank you very much. Can I first say it is a real honor for me to be sitting with two people that I consider among the genuine heroes in this sad, sorry story that we have been living in ever since September 11th, 2001. So truly it's an honor. And if I differ at all from anything any of you have said, it is only with the very greatest respect. I just want to make that clear.
Whoa.
And if I have time in these 10 minutes, I'll do it now and otherwise later. Okay, so what I want to talk to you about today is to step back a little bit and try to give us a framing definition of this thing that we've been talking about, torture, and specifically about institutionalized state torture. Torture as it becomes embedded in a larger society and takes on exactly the kinds of effects that you were talking about, Jameel, that it, in fact, has effects on the moral character of a whole society, especially to the extent that we know that it's happening and still find ourselves unable or unwilling to do anything about it. So when I talk about institutionalized state torture, first of all, I am not talking about Jack Bauer on his lonesome saving Los Angeles from a nuclear bomb by torturing the one person in the 2-hour window who can absolutely save us. That's not how torture works. In order for torture to exist, you need infrastructure. And as Mark said, part of the problem the CIA had when they started their program was they didn't have the infrastructure, they didn't have the trained personnel, they didn't have, which is very odd because they had a whole history of research, but they had kind of lost it. Mm-hmm. I'll come back to that in a minute. Mm-hmm. So here's what I think institutionalized state torture is. It is the intentional infliction of severe mental or physical suffering by an official or agent of a political entity, some political entity, which results in dismantling the target's sensory, psychological, and social worlds with the effect of establishing or maintaining the power of the political entity that's responsible. Okay, so let's unpack that a little bit. It's really 3 parts. It's like a legal definition, a phenomenological definition, which is a fancy philosophical word for what it's like to the person who's experiencing it, and a political definition. So, intentional infliction of severe mental or physical suffering by an official or agent of a political entity. That language is very close to the language that is found in the UN Convention Against Torture and also in the legislation that the US passed in order to put that convention in effect after we ratified it in 1996. And so, as you know, especially those of you who are in the legal world, laws have language on the paper, and then there's interpretation. And so this was a law that the CIA, as has been mentioned before, needed an interpretation for. And so we've talked about the memos. Let me just remind you of the memo, the content of the memo that John Yoo and Jay Bybee prepared for then counsel to the president, Alberto Gonzales, in 2002. And basically, they looked at a couple of questions. First, they looked at this problem of intentional infliction of severe physical suffering. And first they said, okay, for something to be intentional, that means not that you did it on purpose, but that your only purpose in doing it was to cause pain. In other words, if you did it because you thought you could get information by causing pain, that does not fall into the category intentional. Basically, only if you did it for fun does it count. Secondly, the kind of pain involved would have to be of such a great intensity that it was the kind that was ordinarily associated with a sufficiently serious physical condition or injury, such as death, organ failure, or serious impairment of bodily functions. He didn't die, you didn't torture him. Except, of course, we know that now, that in fact, even the torture that was done falls into even John Yu's definition, because there were people who died under torture, people who had permanent impairment of their bodily functions. I also said that torture results in dismantling the victim's psychological, sensory, and social worlds. So what do I mean by that? First of all, when you are tortured in the moment of great physical pain, who here has ever experienced tremendous physical pain? Anybody? Okay, so if you've had that experience, you know that at that moment, your attention is only concentrated on the reality of the pain. It's as if your entire world shrinks down to the contours of your own body. In the same way, your life is completely compressed in terms of time. There's no real past. The past is irrelevant. And there's no future, especially if you're being held, as people are in Guantanamo today, indefinitely, forever, or for an undetermined amount of time. So your time also shrinks. And in the same way, your social world shrinks, because, especially if, as is often the case, you're being held by yourself in solitary confinement, which we are now beginning to understand is a profound form of torture of its own, the only actual interactions you have are with the people who have captured you and the people who are torturing and interrogating you. That is the entirety of your social world. At the same time, one of the purposes, or one of the lines of questioning that people who have been tortured in regimes all over Latin America, in Greece, in the Philippines, in Argentina, Chile, Uruguay, they all report the same thing over and over again, that they would hold out for a day or a week and finally actually give up a piece of information. And over again, they were told, we already knew that, we wanted to hear you say it. And there are a couple of reasons for this. One is to create in the person themselves a reminder of the shame. They have now, in fact, broken their faith with people they love, whether it's family, friends, members of an organization, and they have now to live with this shame of having betrayed the things that they care about. The other reason is, and this gets into part of torture's function, what Jameel is saying is absolutely true, that all along, or at least as early as 2002, you could read in the New York Times articles about things that were happening at Bagram Air Force Base, the use of what they called stress and duress, and stress positions. The information was there. It was in the Washington Post thanks to tremendous courageous researching. Certainly we had the information about Abu Ghraib as a result of Seymour Hersh and also Joe Darby, who actually sent the photographs up the chain of command. We knew. And in fact, torture doesn't really work unless people know it's happening. So, in most Latin American regimes, which are the ones I'm most familiar with, where torture has happened, it is not the case that everyone disappears permanently. Some people are released. And having been released, they attempt to reconnect with their sewing cooperative, their Christian-based community, their Marxist revolutionary gun-toting alliance. And as they do that, they find themselves actually either pushed out, or the suspicion about them permeates the whole organization. And if you ever were in the 60s in an organization and wondered if there was an agent in our midst, you know that that paranoia and suspicion did way more harm than any actual agent might have done. So it tears the organization apart from the inside out. And this brings us to kind of the third part of my definition, for the purpose of establishing and maintaining the power of the entity that does the torturing. And in traditional torture regimes around the world, this happens in the way that I've just said. By tearing apart, by attacking individuals, you pull apart the social bodies that represent any kind of a threat to the organization. But in this case, I think that there was another audience for what William Kavanaugh has called this striptease of power, this sort of now you see it, now you don't. Yes, we're doing it, but no, it's on the dark side, and don't worry your pretty little head. And this other audience is us. And I think what we were being offered was a deal. Here's the deal. You let us do whatever we need to do on the dark side, over here, in the shadows. And in return, we promise that you will always be secure. And the reality is there is no such thing as perfect security. There is nothing that's going to prevent a disenfranchised college student from Chechnya from taking his backpack and blowing up the finish line of the Boston Marathon. Much as we wish there could be perfect security, the reality is we are all mortal, we are all going to die, and the government can't promise us otherwise. The one other thing I wanted to say, which I will just leave for our later conversation, is that there's another locus. There's another place where torture happens every single day inside this country, again, in plain view. And that's in our own jails and prisons, where 2.3 million people are incarcerated in terms of both solitary confinement and the institutionalization of rape. Those are two kinds of torture that go on all the time. And I will come back to that and talk about what race has to do with that. I'm done.
Thank you, Rebecca. Our next speaker will be Bob Cole. Bob Cole is professor of law emeritus at Berkeley Law, where he has taught constitutional law, torts, jurisprudence, and legal ethics. He's been a visiting professor at various universities, including Northwestern, Harvard, Banaras Hindu University, and India. On a personal note, I must say Bob has been my counselor in helping me remove some of my prejudices against lawyers, just because he's such a swell guy. He'll speak to us today about torture and the government lawyer, the legal profession, the citizen. Please welcome Bob Cole.
On behalf of myself, I want to thank Bill very much for, he's a wonderful co-conspirator. And on behalf of the law school, I do want to thank Mark and Jameel and Rebecca for coming here and giving us their time. Each one of these people is very, very busy and has got a lot going on. And Jameel came out from New York just for this, and it's really we're grateful to all three of you. I'm going to talk briefly about torture and the government lawyer, the legal profession, the citizen. And my idea is I just want to state some conclusions about the obligations of each of these three different actors to speak or to act against torture. And I stress that these are conclusions. You know, there's a lot of debatable analysis that I'm not going to be saying, but maybe we can talk about some of it. My first actor is the government lawyer who is giving legal advice to the government about what can be done by way of treatment of prisoners, and what are that government lawyer's ethical obligations in advising about torture. The client in the torture memos was the White House, in effect. That's the top of the line. That's as much responsibility as any client can possibly have. And the stakes were also at the top. They were national security on the one hand, of course, but on the other hand, obedience to the founding premise of the legal system, which is the inviolability of the person. So in my view, when the stakes are that high and the client's responsibilities are that broad, you can't simply give legal advice in terms of arguing to the client how he can do what he wants to do. I think you're ethically required to give a broader range of advice. Remember, these are just conclusions. somebody else may disagree with them. You have to do that in order to protect the clients by your disinterestedness. That's what lawyers are for. And you have to do it ethically because of your own required ethical commitment to the fundamentals of the system, to personhood. So looked at from that point of view, what I think the torture memos would have had to do would be to discuss and confront the central question of the violation of personhood that's involved in torture, to lay out the moral and legal and international risks to the country, to the client that were involved, to look for and evaluate, or ask the client to look for and evaluate other alternatives that don't require torture, to propose some kinds of limits, controls on what the process would be, build them in. In other words, to make the client have to take responsibility for the things other than what he knows about already, which is he wants to do security. You want him to have to take account of other competing interests. And finally, I think the advice should have included the cautionary lessons of history, the Communist Party cases, the Japanese relocation. These are examples where people panicked, and the legal system ought to have built into it some disinterestedness to take the longer view. Brandeis said, and he's usually right, that he said to his clients, I don't know where the line is, but I know when you're getting close to it. And that ought to be enough. So the torture memos, apart from many other professional objections to them, they didn't do any of this. Now, what is the character of legal ethics such that one could make a judgment that I've just made about somebody else's work? That is, how does somebody know that somebody else has broken the rules? And we can do that. You can judge somebody else's actions in the context of legal ethics in this sense, that, or for these reasons, that the lawyer's behavior takes place in a highly structured role. And it's a structured, understood role that functions in society and is supported by society. In doing your job and in defining the role, you use high consensus values and very well-known values. You use standard norms that everybody knows and understands, procedural norms, for instance. And you use methods of reasoning, which are very common. So the effect of that is that talking about the lawyer's role, and therefore his ethics, is something that is relatively familiar and relatively accessible. In that sense, it is public. In that sense, it's public. So that, and it's this public character of the lawyer's role that makes legal ethics, quote, objective, and makes them binding. It makes it permissible for other people to judge your ethics, right? It's because you've got something very structured. Now, my second actor, and you might say that because of this structure of legal ethics within a role, you have the basis for accountability. You have a way to hold the lawyer accountable, and he has a way to hold himself or herself accountable. My second actor is the leadership of the American Bar Association. Now, the American Bar Association is a, she's shaking her head. The American Bar Association is a professional association, it's a trade organization. And its job is to represent the bar to the people and to defend legal values. And to this extent, it has a somewhat structured role. You may not like them, but it has a somewhat structured role. You can think about their somewhat structured role with using some of the same kind of tools that you could think about the lawyer's ethics with. That is, you can apply some common conventional reasoning to what they ought to do, what their relationship to the members are, and so on. And one conventional type norm that I want to stress here is what I'd call a norm of estoppel or quid pro quo, namely that if you justify your conduct on the basis of the virtues of a system, then you have to do what you can do to make sure the system is virtuous. So that if this is a kind of a quid pro quo norm. You want to do that? Fine, then you got to do this. So if you want to justify yourself as an adversary because you are part of a system that creates justice, then you have to do what you can do to make sure that the system does produce justice, which means to live up to its fundamentals, which means to live up to the inviolability of personhood. So in that way, you can construct a norm from the outside that says to the Bar Association, that can't be right.
I know.
You can't count the time I said counted thinking.
Extra minute.
You can construct a norm that says the Bar Association ought to take a stand, and they have taken a stand. They did pass a resolution 10 years ago condemning violence and saying that the United States should obey the Geneva Conventions and international law. I don't know how much they followed up on it. Now, my third actor, and I'll talk about this actor very quickly, skipping over law school faculties and individual lawyers and going to the other extreme, is the individual citizens' moral obligation to speak out against torture. And the idea is, look, it's our government that's doing this. I've got to say something about it, or else I'm somehow complicit. So that's the question. Now, the problem is that as a citizen, you're not in a clear role. And generally speaking, talking about citizens' participation, there aren't that whole cluster of common, conventional, high accessibility norms that say, oh, you've got to do this and you've got to do that. It's a much different situation. And even if there were norms, they would not tell you which things you have to speak out against. You can't speak out against everything. So they wouldn't tell you whether you have to be for abolishing torture, promoting the minimum wage, saving gorillas, supporting public radio. There are no standards for that. Given that there aren't, the issue of whether I'm going to speak out against torture, whether I'm going to do something, that becomes what I'm going to call a private decision. That doesn't mean it can't be objective and it can't be binding on you, but it's through a different process. You have to make it objective yourself and bind yourself to it. So what happens is that your private moral decision to speak out or not to speak out is a private decision. And if we want to discuss all of these private decisions publicly, they morph into political questions. That's what's happened, for instance, with reproductive rights. So it's very hard to say for other people, you ought to speak out against torture under a theory that would justify your doing so along the lines of a role. That doesn't mean we shouldn't impose on ourselves that moral duty. So I have 45 seconds left. I concede that back to the panel.
Thank you, Bob. You can see why he's so much fun to work with.